Good day, ma'am. In this video, I will discuss the following. First, what cases are covered by the Katarungang Pambarangay Law? Jurisdiction of Katarungang Pambarangay, or the Katarungang Pambarangay is jurisdiction in all cases between parties residing in the same municipality, except, first, where one party is the government or any subdivision or instrumentality thereof. Second, where one party is the public officer or employee, and the dispute relates to the performance of his official functions. Third, where the dispute involves real properties located in the different cities and municipalities, unless the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. Fourth, any complaint by or against corporations, partnership, or judicial entities, since only individuals shall be parties to barangay conciliation proceedings, either as complainants or respondents under the Section 1 Rule 6 Katarungang Pambarangay Rules. Fifth, disputes involving parties who actually reside in barangay of different cities or municipalities, except where such barangay units adjoin each other and the parties thereto agreed to submit their differences to amicable settlement by an appropriate lupon. 6. Offense for which the law prescribes a maximum penalty of imprisonment exceeding 1 year or fine over 5,000 pesos. 7. Offenses where there is no private offended party. 8. Disputes where urgent legal action is necessary to prevent injustice from being committed or further continued, specifically the following: A. Criminal cases where accused is under police custody for detention. B. Revised Katarungang Pambarangay Law, or petitions for habeas corpus by a person illegally deprived of his rightful custody over another, or a person illegally deprived or on acting in his behalf. C. Actions coupled with provisional remedies such as preliminary injunction, attachment, delivery of personal property, and supporting during the pendency of the action. And D. Actions which may be barred by the statute of limitations. Any class of disputes which the President may determine in interest of injustice or upon the recommendation of the Secretary of Justice. 10. Where the dispute arises from the Comprehensive Agrarian Reform Law, or CERL, under the section of 46 and 47 Republic Act 6657. 11th, labor disputes or controversies arising from employer-employee relations on Montoya versus Iscayo et al. 171 SCRA 442 Article 226 Labor Code as amended, which grants original and exclusive jurisdiction over conciliation and mediation of disputes, grievances, or problems to certain offices of the Department of Labor and Employment. 12. Last but not least, actions to annul judgment upon a compromise which may be filed directly in court. See in Sanchez versus Tupas in 158 SCRA 459. For the question number 2, give 4 exemptions of Toretto. First, where one party is the government or any subdivision or instrumentality thereof. One example of this is so when a property is expropriated and expropriating proceeding is filed, there is no need for it to go through the barangay. Second, where one party is public officer or employee and the dispute relates to the performance of his official functions. Example is a police officer. So when a complainant and police officer live in the same municipality or city, and what our complainant is complaining about here is because of the official function of the police, then there's no need to take it to barangay. Number 3, where the dispute involves real properties located in different cities and municipalities, unless the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. Example of this is when a property person of person A and person B is located in different municipality or cities, they don't need a barangay jurisdiction. 4. Offenses which the law prescribes a maximum penalty of imprisonment exceeding 1 year of a fine or over 5,000 pesos. Example, if a person committed a crime and it reaches the penalty exceeds 1 year and over fine of 5,000 pesos, there's no need for us to take it to barangay. Question number 3. Unless they are themselves parties to dispute, lawyers are not allowed to appear in the barangay conciliation proceedings. Explain. It is because the prescription of lawyers during the Katarungan Pambarangay proceedings stems out from the very reason that the presence of them could drag the case into delay. In this kind of proceeding, the barangay captain or the lupon chairman has the power to bring together the parties to amicable settle of their cause or disputes. That's all. Thank you.